Good afternoon. Today is my pleasure to be here with Professor Hans Micklitz, who is a professor from European University Institute Law Department. What is the role of the out-of-court dispute settlements when the disputes are between business to business in the energy sector nowadays?
I think the major purpose of these out-of-court settlement mechanisms in the business sector is just to keep a level of privacy and confidentiality in the sector. You must understand, when you look into the history, that before competition was introduced, that was a very transparent market, in the sense there was only one monopoly and everything was structured downstream. So the communication processes were extremely easy, and litigation was more or less excluded because everything was in one hand. Yeah? And when all the unbundling, the privatization, the liberalization started, that was for all the actors in the field, in the business field, it was just a new experience, so they had to get adapted to this development. And what they learned, first of all, that there are growing conflicts about access, who could get access and should have access to the grid, and for what price, and so on. And over time, they had to learn how to handle these type of conflicts. And I think there is a general experience in the business sector that there is this tendency to solve problems in-house. Means not to go to court, that would mean it's public, but try to find amiable solutions, friendly solutions that people can live with. Yeah? So and that's how it started, and over time it was simply formalized. You know, there was a need, obviously, not to leave it entirely to the competitors or to the regulators and the regulatees to solve it in some form of negotiation, but to bring it into a kind of a format, a proceduralized format. And that's why you have this tendency in the energy sector to introduce rules that lay down certain standards even in the business-to-business sector on how they solve problems and under what conditions. I think that's the major thing. What is equally interesting is what we learned in the workshop is that there is so much arbitration, what I did not know. Yeah? I did not know that in the last couple of years that obviously the type of conflicts had reached a level where these friendly solutions, if I may say so, where you simply come together and you look for a mediator, you look for a way to continue cooperating, maybe in a different market design, but still continue, where this has become more and more a problem, because arbitration is a kind of it's a private court, if I may say so. Yeah? So you have arbitrators and they decide. Yeah? They decide the case. The advantage is that it's not public. Yeah? So at least it's not public, we must be very clear here. It's not public to the public at large. Those who are working in the energy sector, the big companies, the big regulators, the big law firms, they will know what the conflicts are. Yeah? And they will know what has been decided in Stockholm or in Paris or wherever in an arbitral body.
The same tendency that you see in the B2B disputes in the energy sector, you can find also in business to consumers. Consumers bring disputes to out-of-court settlements instead of courts. So what is your opinion about that in the energy sector? What is the role of ADR directive in the energy sector, alternative disputes resolutions?
Here it is a substitute for a court litigation, which doesn't make sense. Because most of the conflicts, let's say consumers are complaining about billing, yeah? or they're complaining about prices. That means the value which is really at conflict is rather low. It may be 100 euros or 60 euros or 150 euros, and nobody goes to court for 150 euros. So in a number of countries it's simply too costly and too lengthy, and that's where all these out-of-court dispute settlement bodies are just filling a gap, you know. That is more or less the only opportunity for private customers to get something, some compensation. Otherwise, they would get nothing. Yeah? So, but by this privatization exercise, what you can see is that also the type of conflicts in the relationship between business and consumers have grown. You have more conflicts, and that raised the need to institutionalize it, to have in the company or outside the company institutions, dispute settlement bodies that are professionalizing and that they are handling these kind of conflicts. So that's where it comes from.
And being the ADR directive into force very soon, what it means to the energy sector?
For the energy sector, it means to bring the very divergent rules all over Europe on what an out-of-court dispute settlement mechanism means into a kind of standardized format. Yeah? Example, independence. They should be independent. So what does it mean? What does it mean to have a dispute settlement body that is independent? That will be certainly create lots of problems. Does independence mean that it can no longer be in-house? Does it mean that it has to be externalized, outsourced? Yeah? Does independence mean that you have also personal independence in the sense that you need people who are in no way related to the business? Yeah? So I think the ADR directive really puts quite a challenge on the energy sector to standardize all over Europe, Yeah?